Welcome back. Thank you very much for staying with us. Now, the ANC does not want to hand over its deployment committee records to the Democratic Alliance. It's appealing a court ruling ordering it to grant the party access to 8 years of documents. The Johannesburg High Court ruled the records be handed over within 5 days. Let's discuss the implications now of this with legal expert Benedict Phiri. Mr. Phiri, good morning, and thank you very much for your time. A very short judgment. I think I read it in just under 20 minutes, but with such huge implications for the ANC. Your views?
It is a short judgment, and I think that the matter required a bit more of a lengthier judgment. I think the test around access to information held by private bodies, including political parties, really wasn't properly articulated and fleshed out in this particular judgment. So I think as it stands, the ANC may have a solid ground for appeal, provided obviously they articulate those grounds properly. And I think my problem with the judgment is that when a person requires access to information from a private body, they need to show that that information is required for the exercise or the protection of rights. And I think Mr. Schreiber here, all he showed was that he needed the information to continue input into the Cadre Deployment bill that the BPA wants to introduce into Parliament. As well as
oversight. He mentioned their oversight role. And then the last one was for future litigants, that if there are going to be those that apply for a particular position and are not accepted or don't fare well, then they might want that information to understand the processes of cadre deployment if they want to litigate. I know that one was blasted, it was dismissed. So they had advanced 3 reasons insofar as Section 50, subsection 1A is concerned of PAIA. But even to me, I'm glad you mentioned that the judgment was quite thin on detail. I was quite surprised. I thought maybe there's more. So you're saying that there are prospects here if the ANC wanted to appeal, which they've since indicated they will be?
Yes, there are prospects, and that's because there's constitutional court judgment. I think the DASA versus ANC case, for instance, and an SCA judgment, which involved Anglo-American, which sets out what we mean by information that's required for the protection of a right. And firstly, you've got to identify a right. So the fact that you're bringing a bill in Parliament is not a right. And you have to show why it would be needed for the exercise of that right and what would happen if you didn't get the information to the exercise of that right. And certainly that didn't come anywhere from the judgment. And I think it would, allow the ANC at least reasonable prospects of success in appealing this judgment.
But when listening to Advocate William Curry's response just to that, insofar as the first one is concerned about crafting legislation for the bill, that they would need this information, he went on to say merely that it's not necessarily exercising a right. It's your duty to be crafting legislation or putting forward bills. Was that enough, though, that in as much as you believe clearly that perhaps it was a weak reason advanced by the Democratic Alliance, but how strong was the side of Mr. William Curry in his response?
It certainly wasn't strong because, again, if you look at the Constitutional Court and Supreme Court of Appeal judgment from this very test, the question would be, well, as Parliament, do you have any other measures to be able to get information that would allow you to craft a cadre deployment bill? And certainly we know Parliament has many measures to get hold of information, even from different legislatures around the world and how it works in different instances. But I don't think, the minutes of the ANC specifically would have prevented them from being able to cross this bill and debate it and put it through the parliamentary process. So I don't think it was enough. And I certainly think that the judgment wasn't strong enough in favor of Mr. Schreiber in this particular instance.
I want to take you back to more of the issues here that were being contested, or the legal questions. The issues were narrowed down from 6 to 2. It was 1 being the DA's locus standi, and then 2 being whether the request for the documents complies with Section 50, subsection 1A that we've been speaking of. That's the Promotion of Access to Information Act. Now, if we just start with the DA's locus standi, they suffered a blow, and that's purely because they failed to follow the requisite process to rely on PAIA, where here they just basically failed to request the documents from the ANC, after which they would have refused and then relied on PAIA. What did you make of that? Was it not perhaps an elementary mistake? They should have just gone for an application to join in as amicus curiae.
Yes, it was an elementary mistake on two levels. The first is that they should have also requested that information because the law is clear that when you have a mechanism such as fire, you must exhaust what is provided by that legal mechanism before you can enforce the right in court. So as far as the DA was concerned, they hadn't met the requirements of Section 50, subsection 2, or 1B rather, of fire, which requires them to meet the procedural requirements for the requesting of that information. Secondly, Mr. Schreiber, as the court noted, had, not properly joined the DA. So the DA could have actually requested leave to intervene in those proceedings or to join those proceedings, which they did not do. So as far as the DA is concerned, it's the end of the matter for them. And really this matter is between Mr. Schreiber and the ANC because the DA did not feature. And I think it's quite clear that they haven't triggered the requirements of fire to be able to participate in this case.
So if the African National Congress is listening today, you're saying that there's a strong possibility that they could win this on appeal?
Absolutely. I think the chances are reasonably good that they could win this on appeal. There are Supreme Court of Appeal and Constitutional Court judgments that indicate and substantiate my views from my perspective.